really did this come about? It was for a few years before our founding that it was known.
It goes way back to the English tradition and the Magna Carta. The whole idea was that under a system of laws, that the individuals who are supposed to be the objects of those laws help to frame them. That's what the Magna Carta was all about, and the trial by jury system was a way for individuals in a small town to help to decide and implement the laws that govern that town.
Larry,
The full range of evidence they need to make their decisions.
and of course, they would be emphasized that they could rule on the law as well.
On the law, as
How do the judges prevent the jury from getting the information, and how would this work? I mean, let's say we have this concept reintroduced and it's accepted. How does the jury even make the decision on what they want to hear? The judge now comes up, and if there's information, he'll say that's inadmissible in court. Well, how in a practical sense would this come about where the jury could demand or ask for or get more information?
well, we are holding conferences that discuss what access the jury will have to the evidence, and enlarging the amount of evidence and the degree of evidence and so forth that the jury can review before it makes a decision is definitely one of the points. So we've actually formulated not just one amendment which would require that the jury be told it may judge both law and fact, but a series of them we're calling the Bill of Jury Rights, one of which would give the jury access to the full range of evidence they need to make their decisions.
And of course, they would be emphasized that they could rule on the law as well.
On the law as well. This is the reason that's been forgotten and is not used. In fact, that juries are now told that they may not judge the law stems from a decision by the Supreme Court in 1895 called the Sparf and Henson decision, where the Supreme Court decided that juries no longer had to be told that they had the power and the right to judge the law. So it would be up to the judge. Fortunately, people have remembered over time that part of the job of being a juror is to use your conscience, so they sometimes take the risk and do it anyway.
Gee, what's your idea about a voluntary jury? Is there any merit to considering making jury duty voluntary rather than compulsory?
I think there's some merit to that because you're talking about individuals who have stated that they have an interest in the administration of justice in our system. One of the problems with the current jury system is you do sort of draft people, and that always carries some problems with it. You know, one of the real benefits of a reinvigorated trial by jury system along the lines we're talking about is it might remove some of the mystery surrounding the legal process. It might open that process up and help more citizens understand both its benefits and its problems.
Folks, our time's getting a little short. We're going to need to wind this up. So let me ask each of you to comment on the short run for a moment. Gene, what's the next step? What's the first thing that ought to happen to bring more power to the jury?
I think one of the things you can do is, in addition to programs such as this, is try to talk more about the notion of citizenship. It's a very common idea, it's a very common argument, but it's not heard much anymore. And if you talk about citizenship, and not just in terms of going out and voting and register to vote, but in terms of one's obligations towards self-government, and how trial by jury and jury service is one of those fundamental components of self-government, you might begin to erode some of the mystery behind what's going on and help to improve the situation.
And Larry, you've been living and breathing this issue for quite a while now. What's at the top of your wish list?
Well, Mike, we've been out in the streets trying to get a law passed by citizen initiative that would require judges to tell the jury you have these powers that you don't know about formally. We of course, then encourage people to get involved in that. One way to do that would be to contact the National Endowment for Liberty and ask how to get involved with our citizen initiative or with the legislative process, where we are trying to get the legislature to require by law that juries be so informed. Other than that, there's a number of informal things that can be done. We have literature to pass out, and some people are just standing out in front of courthouses handing literature to people and educating them on site, which seems to be working.
Ron, finally, what's your view?
Well, I think obviously we have to have informed citizens if we're going to have informed juries, and that's the key to it. They must be informed when they vote. They ought to be informed and willing to serve on juries. I like the idea of a voluntary jury. I think that goes along with freedom ideas. I think our greatest obstacle is overcoming the arrogance of judges. And if we have enough jurors who are well informed and willing to serve, I believe we can achieve that.
Well, that's where we'll have to leave it. I want to thank our panelists and you for being with us. We'll be back next week for another vital topic at issue.
A address your role as what is known as a pettit or trial jury. Under our constitutional form of government, there are checks against governmental abuse imposed by its citizens. 1, the right to elect our representatives. 2, the grand jury. And 3, trial by jury. The grand jury and the trial by jury are the least known.
We have discussed trial by jury. I would like to take a moment to discuss the role of the grand jury. The grand jury is meant to protect citizens from governmental abuse. It has the role of investigating charges brought by the government to determine if they are merited, not to simply rubber stamp charges brought by the government against an individual. The Supreme Court states that the independent grand jury's purpose is to not only investigate possible criminal conduct, but to act as a protector of citizens against arbitrary and oppressive governmental action. The grand jury is to protect citizens against hasty, malicious, and oppressive persecution, and to ensure that prosecutions are not dictated by an intimidating power or by malice and personal ill will. Without thorough and effective investigation, the grand jury would be unable to either ferret out crimes deserving of prosecution or to screen out charges not warranting prosecution. Obviously, a grand jury could not fulfill its duties if it is only allowed to hear evidence which the government chooses to let it hear. Our founders intended that our independent grand juries protect people from ambitious or tyrannical government employees and laws.
Former New York Supreme Court Judge Saul Woffler once remarked, "A prosecutor can indict a ham sandwich." What is meant is that citizens simply accept whatever they are told by the solicitor. They fail to use the power to question individuals or examine evidence. When we fail to do our due diligence, we become co-conspirators in governmental corruption. It is at the grand jury level that we have the power to prevent erroneous government cases from ever coming to trial. Now that you know your rights, I would like to take a moment to show you some of the many examples of what happens within our legal system.
I felt an overwhelming need to understand why juries were finding innocent people guilty of not filing a tax return when there was no law requiring them to do so. So I went to talk to Marcy Brooks, a juror who used her common sense and did not allow the judge to railroad the jury into a guilty verdict.
He was being tried for 4 counts of not filing his income tax.
Okay.
And our question was, well, what is to decide? Either he did or he didn't. It never occurred to us that he might actually be innocent while at the same time not filing. In the federal government, it is not a felony not to file taxes. Finally, they said, okay, if we're going to get this guy, we're going to have to put it in the state. They called up the IRS agent, Agent Craner.
Craner? Yeah. Robert Craner. Mm-hmm. This is Ken Doherty. He's also an investigator with the Illinois Department of Revenue.
There's a request for a copy of the delegation and authority order.
Right. And I talked to my boss about that, and he said that my badge is that.
Badge is the authority. I thought it had to be in writing.
The last question that the defense asked him was, did you write any of this down? And Agent Craner looked right at him and right at us, and he said, I never wrote anything down. And yet when we saw the video, there he was, writing notes, you know. And so I'm thinking, okay, at this point, the judge is supposed to say, Agent Craner, it is clear that you have committed perjury. It wasn't even noticed. It finally came to the climax. Mr. Harrell looked right at the prosecutor, and he said, I will tell you the same thing I have told over and over again to government officials. You show me the law that requires me to file a tax return, and I'll be glad to do it.
And again, I ask, under what is the requirement that you claim under the 5 duty stuff? And the requirement under the regulations is what section? My question to you is, what particular act